Hello and thank you for joining. My name is Kohi Hassan and today we'll be discussing about international joint ventures. Why do parties set up an international joint venture? What are the common pitfalls encountered when operating an international joint venture? How do we navigate these pitfalls? And when a dispute has arisen between joint venture partners, what are the key considerations? The main benefit of having an international joint venture is that it makes clear the role of the foreign investor and the local partner. Usually, the foreign investor will bring funds and technical expertise to a project. The local partner, on the other hand, will usually have permits, licenses, land, stakeholder relationship, and perhaps access to distribution networks. In some jurisdictions, there may also be regulatory constraints which limit the amount of foreign shareholding. For instance, in Bangladesh, for certain telecommunication infrastructure projects, there's a limit of 60% of foreign shareholding. Likewise, in Indonesia, for certain power assets, it has to be majority owned by either an Indonesian individual or an Indonesian company. Differences in business culture can be very stark, particularly around decision-making and corporate governance. Miscommunications often result because of differences in language and culture. Aligning expectations between parties coming from different working cultures can also be very difficult. For instance, there have been a lot of case studies done on joint ventures between Indian and Japanese counterparts in the automobile sector which have failed. What was clear from these case studies is that the partners have very divergent views on matters such as customer care, style of management, and profit distribution. The long-term nature of an international joint venture can also be another source of difficulties. What was a good deal at the time of entering into the joint venture may no longer be the case after a while. It is therefore not uncommon to have joint venture partners having divergent views, interests, and priorities after some time. Unfortunately, however, terminating the joint venture may be a difficult process. Parties often dispute over the dissolution of the joint venture company and how to value its shares at the time of dissolution. As cliché as it may sound, to a large extent, these pitfalls can be avoided by having a well-drafted joint venture agreement. The joint venture agreement should clearly set out the goals of the joint venture. It should also set out clearly the decision-making processes and what will happen if these processes are not observed or complied with. Importantly, the joint venture agreement should have an element of flexibility to address changes in external circumstances such as changes in market conditions or changes in the regulatory framework. One provision that is useful to include in the JV agreement would be a price opening or profit sharing reopening provision, which is quite common in LNG contracts. What will then happen is, in that situation, a party can ask to renegotiate its financial participation when there have been changes in the market condition. Linked to this, the joint venture agreement should provide for how a party can exit the joint venture early. A robust exit mechanism can avoid costly disputes. It is therefore recommended that the joint venture agreement include provisions such as share buyback, ROFR, which is right of first refusal, drag, tag, which a party can rely on when it wishes to exit the joint venture. Joint venture disputes are often based on breaches of the joint venture agreement. Very often, what is alleged is there has been a large number of small breaches occurring over a period of time. This may pose some evidentiary difficulties to the party relying on the breaches. There's also a particular risk when that party wishes to terminate the joint venture agreement on the basis of these breaches. The terminating party will have to show that the breaches have existed as a matter of fact and that the breaches are sufficiently grave to warrant the termination of the joint venture agreement. Otherwise, the terminating party may be at risk of being in repudiatory breach of the joint venture agreement instead. Gathering evidence may be a challenge where your key witnesses are located in diverse geographical locations or where they may have left the employment of the joint venture company. It is therefore recommended to always maintain a comprehensive record-keeping process. Another good practice to maintain is to always reserve your contractual rights, even when you opt not to take action against your joint venture partner for any breach he may have committed. Otherwise, it could be taken that you have either waived the breach or are stopped from relying on it in the future. We have assisted many clients in setting up international joint ventures and are experienced in making sure that pitfalls, including those pitfalls highlighted earlier, are avoided. In particular, we have solid industry knowledge in sectors such as commodities, power, both conventional and renewables, life sciences, and tech. This means that we are able to anticipate early on what are the specific challenges that international joint ventures in these sectors may face. On the dispute side, we have extensive experience in helping clients manage joint venture fallouts. This includes representing the clients in negotiating their exits from the joint venture or representing clients in formal proceedings such as arbitration or litigation. In fact, given our position as a global law firm, we have represented both foreign investors as well as local partners and fully understand the different dynamics involved. If you have any further questions as to how we can help, please feel free to reach out. Thank you.